Mr. King. Thank you. All right, so you were here yesterday and you heard some of the questions or some of the statements by Mr. Is it Klett? Klett, okay. And I just, he spoke to some of the writings and kind of his position from the church. And I just wanted to get an understanding from your position from the school. You gave me your argument yesterday, I read your briefing, but I just had some follow-up questions kind of spawned by what Mr. Klett asked, and then just some further questions as I kind of went back and thought about some things that I heard yesterday. So, as a primary matter, Mr. Klett argued to the court yesterday that all of the writings of Ms. Hale fall under safety and security school exception. This means that they should not be released. Is that your position as well?
Your Honor, thank you for that question. Just a point of clarification, Mr. Klett is counsel for the school and I am counsel for the respective church.
Darn it.
No, it's fine, Your Honor. The Covenant Presbyterian Church, the Covenant School. And we actually, after seeing your email, we anticipated that this would be your question.
So maybe you all should give a joint, you all should get up there together because it may ping back and forth.
No, that's fine.
Mr. Klett, these may be for you.
So, Your Honor, the church, the way the interveners have structured their respective argument, the church, the school, and then ultimately the parents, is to discuss the progression of the exemptions, starting with the statute itself at 504P and what that means as to information that may be contained in these journals, then to the broader threat of what the journal means to the school community, and then ultimately the Victims' Right Act and the copyright issue that Mr. Osborne is going to address. Your Honor, we operate in a vacuum in the sense that we have not seen these respective documents. But to answer your question directly to what we do know, and we do know what 3 pages says, is that 504P should have applied to all of those pages. Because when we look at those pages from the church's perspective, when we look at what 504P is there to do, it is there to ensure that any information related to school security, any plans related to school security, any record related to school security shall not be disclosed. What we saw from the leaker in this case are 3 pages that related to a planned attack, 3 pages that related to school security, and 3 pages that contained information regarding school security. Your Honor, as you sit here today, you are entrusted as the umpire, the one that calls the balls and the strikes, as Chief Justice Roberts once said, on the application of the law. And here, we look at what our General Assembly has given us as what the law is, what the strike is. And the strike is, if it's any information related to school security, any record related to school security, any plan related to school security, it shall not be disclosed. So from the church's perspective, those 3 pages, if they are demonstrative of what that journal contains, it should be redacted and not produced, Your Honor.
Thank you. Mr. Klett, I'll have you take the podium because the remainder of my questions will be for you.
Yes, Your Honor.
Okay, so if we go back to the statute 107504 P1 in particular, I just want, in regards to 2A at 10504 P2A, is it your position that that change in the statute is substantive or procedural?
Your Honor, I guess 2 things. Number 1, we think the change in the law, we think it would be more remedial and not substantive because it addresses really more the procedure. But we don't think that that's outcome determinative in this case because
well,
we have.
Do.
You do.
So if we look at the language of 2A, it says all school security reports, memoranda, plans note threats and procedures, including drafts that are incorporated in reports created or received by the Department of Safety, must be treated as confidential and shall not be open for inspection. So if your position is that anything that is related to school security should not come out, and then you're telling me that your position is 2A is remedial or procedural, that would mean it would be retroactive or not?
If it was remedial, certainly it would be retroactive, Your Honor.
So if this court is to construe that as remedial and then retroactive, if any of those writings contain threats, is it your position then that 2A applies and then it's all shielded? Or just those portions of the writings that may or may not have included plans, notes, or threats?
Your Honor, we would submit that either under one or the revised statute, that all of these records, none of these records should be open to public inspection, that they are contained within both of those exceptions. Under P1, information that is related to school security shall not be open to public inspection. So we believe that the records clearly relate to school security, so they would be shielded under P1. And if Your Honor were to find that the statute is remedial, it would be even more clear that under subsection 2 that these records would be not subject to public inspection.
Okay. So, let's focus on P1. Information, records, and plans that are related to school security. How does the court then draw the line on what is related to school security? Like what exactly are we concerned about? Are we concerned about a mention of a name? Like how do I determine what is related to school security? Because in my mind, I'm thinking one thing, and perhaps you all are thinking another. So I'd like to really delve into where the line is drawn on related to school security.
First, Your Honor, we believe that the exemption is very broad. It is a very broad, intentionally broad statute. Any information that is related to school security.
But isn't that subjective for me, or in this case, maybe the police to determine whether or not we think or I think that it's related to school security? Like, what standard am I supposed to use? What is the test?
Your Honor, I do believe that it is somewhat subjective, but you've got to look at the evidence that has been presented in the case. And the evidence that we have, really, when you look at the petitioners, first, as was pointed out yesterday, none of the petitioners, with the exception of Ms. Brewer, have presented any evidence on this issue. With respect to the evidence that was presented by Ms. Brewer, essentially it is her position is that production of these records is a threat, a real threat to this school and other schools. So it relates to school safety. Now, their position is that disclosure of these records would be better than non-disclosure. Fortunately, Your Honor, that is not the decision before the court. This battle of the experts, while we believe that the evidence presented by the respondents and the intervening petitioners is stronger, that issue is not for the court to decide whether it's better to disclose or not disclose. The issue before Your Honor is simply, is the information that is related to school safety? And we think that that answer is clearly yes, because the Ms. Brewer recognizes this as a threat to school safety and security.
Now, surely the legislature, in just changing the law, did not intend to add an additional layer whereby which these documents would be shielded from disclosure, would they?
Your Honor, I believe.
In 2A, that's what I'm meaning. If it's remedial and this court is to look at it as a remedial, then retroactive, if those writings contain anything regarding a threat to a school, where in your position, that's all of them, then they are all shielded from disclosure. If I look at the plain language here, do you believe that that's what the legislature intended?
Your Honor, I don't know the legislative intent there. Perhaps it was simply to make it more clear that these records should be shielded in light of further discussions within the legislature. I don't know. But what we do know is that the law that was in existence under P1 is broad enough to cover these records, in our opinion.
And that would be, in your opinion, subjective for me to decide, but anything related to school security. So if there's anything in the record that is not related, or in the writing that is not related to school security, it's your position that that should also not come out, or should, or?
No, Your Honor, it clearly, if something is not at all related to school security or safety, then that is something that would be subject to disclosure. But again, our position is that a shooter oftentimes is motivated by the desire to gain fame and notoriety. And by providing a shooter with that fame and notoriety, by publishing her writings and her thoughts, providing her with that platform to provide her thoughts to the public, though by doing that, you are providing the notoriety and fame that is sought by these unfortunate individuals. And by doing that, the writings, the evidence that we have presented to the court demonstrates that it is a real threat, because there are individuals out there that will grasp these writings, see that the notoriety has been provided, and will engage in copycat behavior. And it is that exact scenario that we're trying to prevent.
And that is the threat, is that correct?
That is a threat, and it relates to school security and safety.
When I go back to the language of P1, we'll focus there. Information, records, and plans that are related to school security. Now, public and private schools both have certain protocols, safety measures that they both have to present to the Department of Education. Is that right?
Your Honor, that would really fall within the area for Mr. King to answer. I know he's much more well-versed on that, and I think he can address that.
Why don't y'all both get up there together?
We'll hold hands.
You don't have to hold hands, but just share so that I can.
All right, Your Honor's question is the obligations for creating school safety plans. Is that correct, Your Honor?
Well, just generally speaking, both public and private schools have certain plans, procedures that they all have to comply with and turn into the Department of Education. Is that correct?
Your Honor, that is correct as of July 1, 2023. You've asked several questions, and I'm going to answer your questions and kind of back up and answer a prior question at the same time. When we look at Public Chapter 367, which was House Bill 322, which was signed into law on July 1, 2023 as a result of the special session, it did numerous things, but the first two things it did is it changed 49-6-804 and required two things, Your Honor. In subsection A of 804, it now provides that each LEA, which is a school district, each public charter school, shall adopt a comprehensive district-wide school safety plan and building-level school safety plan regarding crisis intervention, emergency response, and emergency management. Then it goes on in Section B and provides that each private school and each church-related school shall adopt a building-level school safety plan regarding crisis intervention, emergency response, and emergency management. Both Sections A and B require the LEA and the public charter school, along with each private school and each church-related school, to now file those plans with local law enforcement.
Were they required prior to July 1, 2023 to have any plans created?
Just to have it created, Your Honor?
Yes.
There was no statutory affirmative obligation for private or church-related schools to create these plans. They very well did have plans, but there was no statutory obligation to create them and then subsequently file them. So what happens in the special session, Your Honor, is the legislator now comes in and says, every school in the state of Tennessee that is operating, be it private, be it charter, be it public, be it church-related, you must have a security plan. And not only must you have that security plan, you must give it to local law enforcement. And that makes a lot of sense because, Your Honor, that helps a response. That helps understanding what security protocols are in place when a crisis arises and law enforcement is responding to that crisis, that they have an understanding of what may be going on at that facility as law enforcement tries to go in and breach the perimeter to neutralize the threat, as they did in this case. So, Your Honor, when we look at 496804 A and B, we now know that every school in Tennessee has this affirmative obligation to not only create these plans, but to share these plans. And once these plans are shared pursuant to law with local law enforcement, as we look at the definition of the TPRA, they become public records. So we have a whole host of new documents that are being created. And so, Your Honor, these are now public records. And so this is where you can read Section 2A and 2B in harmony with these requirements, because the legislator amended 504P to add 2A and 2B. And it talks about security reports, memoranda, notes, threats that are shared with the Department of Safety. Your Honor, that's where you read these, that's where the public chapter has to be read in harmony. You have the chapter requiring creation of new records, and now you have 504P with an addition saying those records are protected. And so, Your Honor, that's why we keep focusing on Section 1, because we know Section 1 existed as of March 27, 2023, because, in fact, Section 18 of Public Chapter 367 says the existing language of 504P shall now be designated as Subdivision 1. So, Your Honor, to answer your question, yes, there is now an affirmative obligation for all schools in Tennessee to create and share these plans. But 504P1 still provides that any information related to school security shall be protected and shall not be disclosed. And so when we're looking at what that means, it means what it says, that if these journals, and as I've already discussed, the first 3 pages that have been leaked, we believe, satisfy this requirement, contain information regarding school security, how this individual was going to attack the school, where this individual was going to park, how this individual was going to look at school security. Your Honor, the statute's drafted the way it's drafted because it is a statute that cries out for discretion. It is a statute that cries out for an informed individual in a case like this to look at respective documents to ascertain whether that information relates to school security. School security means the perimeter, Your Honor. It means the security cameras. It means the security guards. It means what teachers are trained to do in a crisis. It means what they're trained to do when a fire alarm goes off.
But what if some of this information is, let's say hypothetically, public on a school's website and utilized in their advertisement? Is that really, can that be construed as related to school security if a school has already put it out there in the public domain?
Well, Your Honor, if you're talking effectively a waiver argument that schools have implemented and have security guards posted, that's one thing, Your Honor. Everyone, when I drop my children off at Julia Green, there's a police officer standing right there.
I'm not talking about what you see every day. I'm talking about schools regularly give tours, make maps, give them out to people, go to anybody's PTO. They give you open house. They're going to give you a way to get around that school. So that's now in the public domain. If a tragedy or an incident happens at that school and that's collected by police, is this court to construe then something that's already in the public domain as it shouldn't come out because it's related to school security, even though the school has already put it out?
Your Honor, the hypothetical you pose is a difficult one to answer because I don't have a comparator in this case.
I don't think we have any comparators at all in this case. So you all are asking me to really construe these laws that have never been tested and determine whether or not, specifically in this case, the writings of Ms. Hale, whether or not she construed her writings to be related to school security.
So let's talk about the first thing you asked, the open house. Every parent knows that respective open house. I've never been to an open house where I've been given an actual map of the respective facilities or the layout.
I have.
But I've been directed. And Your Honor, that is sometimes just a very blank sheet of paper of saying room 207 is located on the second floor at this potential location. That's information that's fairly generic. We can agree to that. That information is public, people can learn about it. But what's not generic, and I think you have to look at it through this lens of what information is being added onto that. That there are plans of this is the access point that I want to utilize. This is how I want to maneuver through the respective building to avoid security cameras. This is how I know that, you know what, there's a police on guard until pickup is over, and that police routinely leaves at 9:30 every day, or the school resource officer doesn't arrive until 11 o'clock in the late morning. That type of information is not uniquely known or broadcast throughout the respective community. And I think that most schools don't share their inherent security plans of how they're going to respond to a crisis.
Well, and I don't disagree with you that that schools generally do not share their security plans. But I don't know that we're talking about the security plan of a school. I think that we're talking about the writings of Ms. Hale, which those are not security plans, right? But you're asking the court to construe them as being related to school security, which begs the question if, you know, a person writes about a school, is that truly related to security? And is that what the legislature intended? You talked about being fairly generic. So is that the rubric that I'm supposed to use when I determine whether or not something is related to school security?
This comes back to the broad versus narrow construction of this exception. And I think I'm always guided by looking at what the prohibition provides. And it's a shall not be disclosed. And it is information related to school security. You know, that word information is a broad term. It is encompassing and gives the court, because you are put in this position under the TPRA as the only person outside of Metro that sees this respective information. And we are talking about, if we step back, we are talking about school security, the protection of children. So, Your Honor, with the broad prohibition that says it shall not be disclosed, and the fact that the General Assembly not only used information when they first drafted it, but importantly, they kept it, Your Honor. The General Assembly had an opportunity in their special session to narrow the construction of 504P. They had that opportunity to narrow it if they wanted to when they passed Section 2. They didn't do that, Your Honor. Your Honor, we're talking, and we are guided by the fact that this is something, school security, that protects the helpless. These are 6-year-olds, 7-year-olds, and at most 18-year-olds that are in these schools. These elementary schools, there are not individuals outside of the teachers. These children cannot protect themselves. So when you're asking me, what is your task? I say to you, the General Assembly said to you, if it's information that you determine is related to school security, you are prohibited from disclosing it. Now,
and that is created by anyone.
That's
is
correct.
Your argument.
That's correct, Your Honor. I come back to the very simple, when we look at this statute, again, it is about content and not the creator. Your Honor, the analogy is under the, I believe under the various Tennessee law when you're looking at governmental tort liability. There's official immunity for governmental entities for officially drawn plans that are the buildings that are designed to spec. And you have to produce those design plans and show they were designed to spec. So the Tennessee General Assembly knows how to differentiate design to spec, official plans, drawings that an architect would do, that an engineer would do, that a contractor would sign off and stamp, as compared to what this statute says, which is just information. It doesn't focus at any point on who created the information. Your Honor, the General Assembly met when this TPRA action was initially filed. They had the opportunity to clarify again that if the information was created by an assailant or a third party outside of the school district or a third party not involved with the school or not an administrator or not a hired contractor, not a hired engineer, not a hired consultant, is not a public record or not subject to this exception. Again, their silence speaks volumes on the authority that they have entrusted in this court that any information related to school security shall not be disclosed. So, Your Honor, when we look at what was done in Chapter 367, and maybe more importantly, what was not done, this court is empowered, entrusted to redact or withhold any information related to school security regardless of how it was drawn. And this just comes down to the logical fallacy in the argument that the creator matters. If an individual walks into a building on a school tour and takes detailed notes about where security cameras are located, where security individuals are located, I think we can all agree that is information related to school security that's not publicly available. But because this individual took it down and then subsequently used it in a nefarious way, and that information was wrapped up in an investigation, that somehow it doesn't enjoy the protections of this exception would lead to the disclosure of sensitive school security information. And Your Honor, I don't know if that's what we're talking about here today because we're talking in a vacuum. But what I do know is that the TPRA provides that any record obtained by a private person pursuant to legal process, which in this case Ms. Hale's journals were, they're a public record, which means now the exceptions apply. That we have to go through that exercise of looking at those respective exceptions. Respectfully, the petitioners can't have it both ways. They can't say that Hale's journals are a public record, but yet at the same time now stand up and say they're not subject to the exceptions as they are drafted. That's an incongruent result, Your Honor.
Okay. I think that's all I have.
Thank you, Your Honor, for your
Thank
time.
you for that clarity. All right, Mr. Osborne, I'll hear from you. One more question, Mr. King, I'm sorry. So again, you all are diverging from from Metro at this point, and Ms. Fox, let me just get some clarity from you on that. You all are taking different paths at this point, or do you agree with Mr. King, Mr. Klett, and how this court should interpret school security and what has been or has not been redacted? Like, are you all on the same page? Are you on different paths?
Yes, Your Honor. As to the school security exception, it's our opinion that the police should redact what they believe affects school security as the experts on security issues, and that the remainder of from the government's position, the remainder of the writings would be released.
And are you, from your legal position, are you construing that broadly as far as school security, or is it a narrow construction? Because the interveners have argued to the court that it's a broad brush, that should be used. And at the end of the day, I will give some instructions to Metro on how that looks. So I would love to know from Metro, are you all using the same broad paintbrush, or are you all using a more narrow, fine tip pen?
No, I think it is written very broadly. I mean, information related to school security, I think, means anything that could affect a school's security, no matter who it's written by, or how it would affect the security. So certainly someone's plan for entering a school and committing a crime, that seems like it affects school security for the future. If someone wanted to follow that plan again, I think that anything that indicates how a person, where cameras are, or why a certain path would be appropriate. I think that information related to school security is very, very broadly written. But I think someone saying, I watched the movie Moana today is not, is different as far as if we call this sort of a diary kind of situation.
So then am I particularly focused on, is it the entrance into the school? Is it student numbers? Like what, again, and I guess that's why I'm the chancellor. Related to school security, it's not defined. And so, if we're talking about orange roses, that's easy for me to determine, right? But if it's something more nuanced and we're talking about, let's say, how many children attend a particular institution, is that in the public domain? Is that related to school security? Where is the balance, and really, how do I determine that? And
I don't
just
think
like to hear your thoughts on that.
Sure. I don't think if it's in the public domain, it's protected. I think if you look at, for example, in the courthouse security is another, government buildings is another issue, another exception to the Public Records Act. So in that case, does everybody know when you enter there's a security station, and then the mayor's office is on the right and there are other offices on the left? Everybody knows that. You can see that if you come in. But everybody doesn't know where are cameras set up, where are security guards located, are there ways that additional security measures may be in place that the public is not aware of. And so I think that's, I think that if you ask, if you get into the nitty gritty like that, in this church, where is the sanctuary? I think that's something that is public domain. But I think knowing more specific information that's only privy to someone who's planning a crime or who is working for the school, I think that's different.
Okay, so you think that it is kind of like insider knowledge, and so if these writings do not contain anything that a normal passerby may observe, even if someone were to come and tour a school you're talking, or it's Metro's position that when we talk about school security, I'm looking for specifics.
Yes, that would be our position. And I certainly don't mean to indicate that the metropolitan government is adversarial to the victims' broader arguments.
I'm not saying that,
But
you
we're,
all are taking different
yes,
paths,
we're taking
right?
a different path under the established law for what governments are required under the current case law.
Okay, all right. So your position is specifics, and Mr. King and Mr. Klett, your position is anything that a passerby may observe, or someone coming to visit a school, you know, if I recognize that there's a door, you know, on the right, is,
So, Your Honor, there's the statute's written information, records, and plans. That's the trilogy that is included as preceding related to school security. So right now, we're talking about information, and you're talking about information that can be gleaned by the public. I think what Mr. Klett and I are also saying, anything that is related to a plan, that an individual, for example, the assailant in this case, planned to enter the building at this spot, planned to park at this spot, was looking for security. That is a plan that is related to school security. So that should be exempted from public disclosure as well. That is what we are arguing. So, Your Honor, I think you have to look at all three of those words together when ascertaining 504P1 and its application here. To your point, a generic map of where the sanctuary is, and the school entrance is here because there's the sign that says the Covenant School. That information, I think, is generally known and would maybe fall out of the purview. But the commentary by this individual, and I reference back to the 3 pages, the commentary by this individual is a plan, and that plan relates to how she's going to pierce the envelope of this building and take action within that building and assault and murder those individuals within that building. Under the school security exception, that's a plan related to school security. That's a plan related to security of the property and how she's going to evade it. And, Your Honor, so that's a concrete application, in my opinion, because we know what we're talking about with the leaked pages. And
because there's not been a case like this before, when I draft an opinion, and assuming it goes up on appeal, while this is case specific, it will be case precedent. You know, so I understand that we are talking about this case, but we are also talking about cases broadly, right, and how this gets construed broadly. And so that's why I'm kind of in the nitty-gritty, because right now you all are asking me to adopt an interpretation of the statute that would say a plan or a writing in a journal is construed to be information, records, and plans that are related to school security and thus exempted from, you know, disclosure.
So this is where context matters, Your Honor, and this is where we actually come back to the plain and ordinary terms of the statute, because that's what we're guided by. And so, Your Honor, what we are advocating, what the church, the school is advocating, when we're looking at the school security exception in this particular case, is the statute means what it says. That any information, any plan, any record related to school security, and school security is there for a reason. It's not related to the school. That's important. Security exists in this sentence.
So let me ask, hold your thought. So any mention of the school is not related to school security, right? So let's say in this journal, in this diary, there are several mentions of the school. In your opinion, that's not related to school security, correct?
I like how Ms. Fox worded it. If we're talking about a diary and the assailant wrote, or any individual wrote, I went to the Covenant School, period. That is my diary entry on January 2nd, 2023. That's not related to school security. That's a comment. That's a fact. I went to the Covenant School. Or I enjoyed my time at the Covenant School. Or I had a hard time at the Covenant School. None of that relates to security. But when we look at what we have in front of us, the 3 pages, we have an ascertainable plan and how that plan was being put into effect and the targets of that plan. And those were children, school children. And so I think that's the distinction, Your Honor, that we are talking about the security of the premises, how the premises is locked down, how it is patrolled, how teachers interact with their students when there's a fire drill, how teachers interact with their students now, how there's an active shooter incident or active shooter training. Those are all security plans. Where an SRO is placed, where the SRO patrols, Your Honor. I mean, this is a campus, and like many campuses now, many schools, there's a patrolling security officer on the campus at times. So where that person is at particular hours, the routes they take, that is all unique information related to school security. So, Your Honor, when you're looking at the application of 504P1 to not only this case, but how someone would have to apply it in the future, how Metro will have to apply it in the future, I think the words of the statute guide you, and that is the information, plans, records related to school security. So the threshold inquiry is it related to school security? Are we talking about something that will open the school up, provide insight to how they secure their premises, how they protect their children, what plans they have in place to respond to emergencies? Then if it's an information issue, if it's a record issue, or if it can be construed as a plan, the legislator has told us it shall not be disclosed for public inspection. Comparatively, if it's a commentary of, I enjoyed my time at Hillsborough High School, or I really like playing on the basketball team at Hillsborough High School, I made great friends there, in a journal, and that's one page. And then the very next page says, I'm going to go into Hillsborough High School and take the lives of X, Y, and Z at this time. Your Honor, the first page about enjoying the basketball team, you could say that is a public record and it can be disclosed. On the other hand, Your Honor, that second page, that's a plan related to school security, how that individual is going to pierce the security of that school and carry out an attack there. It's written in a way, Your Honor, that by the application of its plain and ordinary terms, the judge, the courts, Metro, have the ability to make that distinction. Because unfortunately, Your Honor, as you said, this case is a little sui generis to its own facts as to what's in front of you. And we only can be guided by what the General Assembly has told us in the words of its own respective statute. And in this particular case, it's important that this case is sui generis because the next one will be as well. I hope and pray that I'm never here on the next one, Your Honor. I hope and pray you never sit there on the next one. But, Your Honor, the facts of each case are respectively different. And that's why construing this statute broadly, but having at least it tailored to school security, empowers Metro, empowers the court to ensure the safety of our children are preserved. That security that is implemented to ensure their safety remains exempt from public disclosure so that we don't make it easier for the next one.
Okay, thank you.
Thank
Does
you, Your
anyone
Honor.
else want to speak on that issue? Okay. I know the petitioners will have rebuttal on that, so, but I'll hear from you all at the end. All right, Mr. Osborne.
Thank you, Your Honor. And I will have a couple comments that relate to this issue.
Give me just 1 second to close. Okay. I'm ready whenever you are.
Thank you, Your Honor. Your Honor, Eric Osborne, on behalf of the parents of the minor covenant children Jane Doe and John Doe. I'm here today surrounded by colleagues, Your Honor, from Sherrard Rowe, Spencer Fain, and the Hal Hardin Law Office. We have come together as 3 law firms to help the parents in this, their time of need. And I want to also recognize, Your Honor, that most of the people in the courtroom, I think practically everyone who's not media, is a Covenant parent who is here today, or a relative of a deceased victim. And I want to acknowledge and honor their presence today. Your Honor, the first thing I want to do is I want to say thank you. Thank you for letting us be heard. I know one does not normally begin an argument like that, but the parents are truly grateful to be here today. And as Your Honor well knows, we have had intense opposition to even have the ability to make our arguments. And so I want to start off by just acknowledging that and say that we are grateful to be here and we appreciate this opportunity. I want to do several things today, Your Honor. I want to give a brief introduction that frames the issue for the parents. I want to then talk about 3 legal issues that are the 3 legal issues we are relying upon to ask that the shooter's writings not be released. All 3 of those legal issues, we would say, are adequate and independent reasons for this court to rule that the shooter's writings not be released, and we would ask that the court please rule on all 3. As the court has noted, there's likely to be an appeal here. In particular, I'm going to focus on the copyright and the Victim Rights Amendment, but I am going to say a little bit about the school safety exception and the relation there. So after the intro and then the 3 arguments, Your Honor, then I've got a brief conclusion I'd like to give as well.
Okay, so I have questions.
Yes.
Based on some statements made by Mr. Hollow yesterday and just kind of how the case has progressed.
Yes, Your Honor.
So do you want to you can get into your argument.
Okay.
And I will do my best not to interrupt. And then I have several questions.
Yes, Your Honor, thank you.
Position.
So yeah, if you don't mind, I'll give this brief introduction and then I'll jump into the school safety stuff.
Okay.
And I look forward to answering all of your questions whenever they pertain to whatever I'm discussing, Your Honor.
Okay, and I may interrupt you, so
Understood.
don't take offense.
Absolutely. Thank you, Your Honor. Your Honor, on March 27th, 2023, the Covenant School children fled a violent attack at their school. They went back yesterday. I couldn't believe it when I learned that this hearing was set for the very day that they returned. Today is their first full day back at the school. Yesterday was an orientation.
Well, in all fairness to the court, I didn't know.
No, that's true. Actually, when I called the parents after you set the date, me having no idea, they said, wow, that's interesting. But I think it's actually appropriate. That's the reason I start with this. It's fascinating that today of all days, the day that they return to school, is the day that we are here talking about them, Your Honor, because this case is all about safety. It's about safety for the children, safety for the families, their constitutional right to be free from abuse, harassment, and intimidation, their statutory right to be treated with dignity and compassion, and indeed safety for all children everywhere. When we started this case, in our opening brief, Your Honor, we talked about words like Columbine and Sandy Hook and Parkland and Uvalde. And we noted in our opening brief that those words conjure images in the American people of terrible, terrible things. And we said that our hope is that the word covenant will come to conjure something different. And fundamentally, that is why we are here today, because as far as we can tell, and I think the court is aware of this, there's never been a case like this any time in American history where, because of the unique procedural posture, we have the ability to tell the story of the survivors and the impact of what has happened upon them, and to have a chance to stop a shooter's writings from being released and to stop that celebration of violence that we see too often in the media, and to say that the story can be different, Your Honor. And I will return to this at the end about why we hope that the word covenant from this case will eventually come to have a different meaning and a different memory in American history. Now, our position, I want to be clear, our fundamental position is that the writings of the shooter should not be released. There have been some media reports suggesting we have said nothing should be released, and that is not accurate. We have said that we want Metro's police report to be released, for example. So we are not trying to cover up information like some people have alleged, but we are very specifically focused, as the parents, on these writings not coming out.
Now, Mr. Osborne, are you focused on the writings found at the scene or all of the writings that have been collected in the investigation?
No, all of the writings, Your Honor. Thank you for that. And something I'll talk about during copyright is that, I would also include in that things like videos or photographs that the shooter may have made, because, as I'll discuss when I talk about copyright, those were also transferred to the parents. So really we're talking about media that the shooter produced is what we would ask not be released, Your Honor.
So any media, whether it was found at the home, in Montana, doesn't matter?
If the shooter created it, Your Honor, yes, our position would be that it should not be released. In general, now we can get into some particulars if Your Honor would like. I've got an observation on one thing that I can make when we talk about copyright. But in general, our position is that none of that should be released.
And you agree with me that at this point in time, you and Metro are taking divergent paths?
Absolutely, Your Honor. No, without doubt. Without a doubt. In fact, that was one of the reasons both for our intervention and for the Court of Appeals affirming our intervention, was that Metro did not represent our viewpoint.
Okay.
Thank you. We have 3 reasons that the document should not be released. The first is the school safety exception. The second is copyright. And the third is the Victim Rights Amendment. As Mr. King and Mr. Kled have pointed out, they focused on the school safety exception. So I do not have too much to add to that except to say 2 things. The first is that we agree with Mr. Kled that related to school security should be read in the broadest possible term, and that if it is true, and I would submit it is, and I'm going to talk about this in a moment, that the release of these writings have a real danger of leading to additional violence against the Covenant School or other schools, then the release of those writings does relate to school security, and they should not be released. Now,
But how can the court quantify, what at best that at this point is speculative? I know I said I wasn't going to interrupt you,
Yeah.
but
Yeah.
you all have been before me before. You know how this goes.
No, I do. And Your Honor, I've got the Elmo on because I know that the court
Okay.
sometimes likes the Elmo. Because hopefully I've anticipated where you're going, and I'm going to hopefully provide some answers. And the thing that I wanted to start with is there was a comment made yesterday by Mr. Pierce. He talked about Mark Gwynn, who was a person who gave us a declaration. And I think Mr. Pierce said something to the effect of, who is this guy? Who is this guy to opine about whether release of the writings will lead to more violence? And Mark Gwynn's declaration, I think, is actually very important on a host of levels, Your Honor. So I'd like to start with that to sort of wrap up the school security exception, and because I'm going to use it in several other points. So if I may, I'm going to put this on the screen now. And I want to talk about who Mark Gwynn is, Your Honor, because I think Mark Gwynn is an amazing man, and I cannot tell you how grateful we are that he has given sworn testimony to this court on behalf of the parents. Mark Gwynn was the former director of the Tennessee Bureau of Investigation. He was the director for 14 years until Mr. Roush took over in 2018. So he is the most important law enforcement official who is not still working in law enforcement who could speak to this issue. For 14 years, he ran the TBI. He was the first ever African-American man to run the TBI. He spent his entire lifetime in service of law enforcement. Before he became the TBI director, he was a special agent investigating some of the highest profile crimes in the state. He was the assistant director in charge of forensic services. He worked in the police department before that. He has had extensive training from the TBI, the FBI, even the Israeli National Police, Your Honor. And all of this goes to answer, who is Mr. Gwynn, as Mr. Pierce asked yesterday. Mr. Gwynn is also an incredibly decorated and awarded man, Your Honor. In 2006, he won the award as the Distinguished African American Alumnus of MTSU. In 2010, he won the overall award as the most distinguished alum of that university. That is the basis upon which Mr. Gwynn says that it is well known among law enforcement writings, that writings such as the writings of a shooter clearly inspire copycat shootings. And he, the former director of the TBI, has told this court that Tennesseans will be safer. Told this court under oath, Your Honor, told this quote under oath, as the former director of the TBI, that Tennesseans will be safer if these writings are not released.
Now, that
and-
is indirect, well, Chief Hagar has a different opinion, and he currently is with Metro, submitted a declaration that said at least a redacted form could be released. So how is the court to look at both of these men who both are representative of law enforcement in its contemplation of whether or not it's safe to release these?
So I would have two observations. The first is, as Mr. King said yesterday, Your Honor has a difficult decision. We acknowledge that, because to the extent you think you have conflicting facts, you'll have to find findings of fact in order to apply the law. I don't think Chief Hagar's declaration is actually inconsistent with this, because I don't think Chief Hagar was even thinking about this or applying this at all. His declaration was very early in the case. I believe it was right around the day that we were allowed to intervene. So Chief Hagar never had a chance to see the proof that the parents put on from Mark Gwynn, from Dr. Erica Felix, who NPR referred to at one point as the greatest expert in childhood shooting and trauma in the country. He never had a chance to see any of that. So we don't know how he would feel if he were asked that question today, Your Honor, and I don't believe his declaration is inconsistent. I think his declaration was limited to the issues that Ms. Fox has stated for Metro, which was, with the redactions that I have identified here, we will have satisfied Metro's narrower view of the school safety exception. So I don't think there's actually an inconsistency there, Your Honor. That's how I would answer your question.
Okay.
Now, to wrap up the school safety thing, because again, Mr. Klatt and Mr. King have done a really nice job in that, Your Honor. You've got, Mark Gwynn is the one I want to focus on in particular, and I'm going to come back to his declaration later today. But you also have Dan Hodges and Michael Moore, two well-respected people with great histories in law enforcement who have given you similar declarations. You've got Dr. Felix, who has given you, I think, an outstanding expert report, and we're honored and grateful that she was willing to help the parents with that, Your Honor. And then all you really have in opposition, as Mr. Klett said, is the declaration of Ms. Coleman, does not have a doctorate, I believe, in the same way Dr. Felix does, is not a well-published scholar in the field like Dr. Felix is. And even her declaration tends to acknowledge a lot of what we said, which is that copycats do exist, they are a threat. And really, you know, as Mr. Pierce dealt with yesterday, she addressed the idea that, according to Ms. Coleman, the risk goes away after 14 days. So it seems to me that what you have is you have complete agreement from everyone, including the petitioners, that there's a danger of copycat attacks. The only dispute that I see in the record is whether that threat goes away after 14 days or not. And on one side, you have Ms. Coleman saying it goes away after 14 days. On the other side, you have Dr. Felix saying something different, and the former head of the TBI and other law enforcement officials saying Tennesseans will be at risk if these writings are released. And I would humbly request, Your Honor, that the court take the broad view that Mr. Klett and I have been arguing and say that related to school security should mean that these things don't come out at all. And then I want to say related to that, my third argument is going to be on the Victim Rights Amendment, which says that victims have a right to be free from abuse, harassment, and intimidation. If it is true that the release of these writings will endanger these children, the school safety one applies to the Covenant children and all children in Tennessee and elsewhere. But at least with regard to the Covenant children, if it is true that the writings could inspire copycats, and that is what Mr. Gwynn has told the court under oath, then I would say that that means the writings absolutely will harass and intimidate the children because their very release will subject them to an increased risk of another attack, Your Honor. So Mr. Gwynn's argument and the factual arguments that support the school safety exception also support, Your Honor, what we're going to argue under the Victims' Rights Amendment. And with that, I want to pause and see if Your Honor has any other questions on the school safety aspect before I turn to copyright.
I think that your colleagues answered, and I will hear a rebuttal from the petitioners.
Thank you, Your Honor.
I do have one question before. Is the court to construe, I think you just argued to me that the court is to construe the exceptions broadly.
Yes, Your Honor.
Is that in conflict with the TRPA that says, you know, in Tennessee, we like open records, let the sun shine in. If I construe the exceptions broadly versus narrow, does that not conflict with what the legislature has said? They like open records. We want to allow everything to be open, basically open government.
I think the immediate answer that comes to mind, Your Honor, is the Griffin case that Your Honor talked about, where the Supreme Court said that there should be a balancing test applied about the totality of the circumstances. Now, I can argue Griffin a little bit, though it's not one of our principal arguments. I mean, I'm focused on 3 other arguments. But I think that the Supreme Court said that when we consider, yes, there is a general public policy in favor of disclosure, first of all, and this again reiterates what Mr. King and Mr. Klett said, I think that the Open Records Act is, I think we can all agree, primarily meant to be about government-created records. This is a weird case in which you have something that is unquestionably private writings that, were it not for this horrific event, would never have been in the possession of the government.
But that's going to be every person who is involved in crime. The way that, unfortunately, the way that this statute and the case law has been decided, if you become a victim of crime and your personal information, whatever is collected at the scene, whatever, it becomes subject to open records.
I agree, Your Honor. It becomes subject to open records.
And anyone, a citizen of Tennessee, can come in and file a request and get your private information.
I agree, Your Honor, that that is what the law says. And then the law says that there are exceptions. Here, we actually have exceptions that apply because we have the school safety exception, the copyright exception that I'm going to talk about, and the Victim Rights Amendment. Now, the Victim Rights Amendment, before it can apply, you've got a threshold level you've got to show, which is that the writings will relate to abuse, harassment, and intimidation, which is often not going to be the case. But if I may, Your Honor, I want to delve into that more detail when I get to the Victim Rights Amendment portion of my argument.
That's fine.
So, okay, Your Honor, with your permission, I will move on to copyright at this point, okay? So, and let me get my... Sorry, Your Honor, I've got a lot of papers up here.
It's okay.
Well, Your Honor, I'm going to begin, and then I'm going to look for another piece of paper later when that comes up. I was trying to get it all organized before I start
It's all
copyright.
right. Take your time and get organized.
No, that's not it. Where is... Ah, there it is. Okay, Your Honor. Our second argument relates to copyright. Last June, in what I think can only be described as an act of amazing grace, the parents of the shooter, Ms. Ronald and Norma Hale, transferred ownership rights of all of Ms. Hale's intellectual property to the parents. Now, why did the Hales do that? They told us why in the filing that they made with this court. Whereas the Hales desire that no further harm come to any of the children who survived the events that took place on March 27, 2023, and whereas the Hales desire that no further harm come to any children or adults anywhere in the world because of the writings. Ronald and Norma Hale transferred ownership of the writings to a special trust called the Covenant Children's Trust for the very purpose of protecting these children, Your Honor, and of protecting all children. And I am very pleased to be able to stand before you today and tell you that that transfer is now complete. There was a comment made by Mr. Berry yesterday about how this was some contingent right. That is not the case. That is why last Thursday we filed with the court the confirmation of the assignment of the rights. Now, I am not an estate lawyer, Your Honor, but Mr. Jeff Mobley has been the estate lawyer that has handled the estate of the shooter. And Mr. Jeff Mobley has handled that and has informed me that the time period for creditors to emerge has passed, now that more than a year has passed, and that the action is complete and the ownership is now complete. And so, Your Honor, I stand before you today now as the legal representative of the owner of the documents in question. Now, that ownership that we have and that became official last week and that we filed with this court, 6 days ago now, that ownership is a paradigmatic change in this case, Your Honor. And it's paradigmatic because copyright exists from the moment that a work is created. And I want to take a moment and try to walk through that a little bit, Your Honor. And I've got another demonstration about that I think is going to help answer some of the questions Your Honor had about copyright yesterday. Your Honor, may I approach the bench?
You may give it
Okay.
to my court officer.
I've got copies for y'all, yeah. So, Your Honor, we argued this point in our brief, but I have printed off an exemplar, and you can see at the top left, it says Copyright in General, FAQ, U.S. Copyright Office. You see the URL to the right. This is an FAQ that I printed off from the United States Copyright Office yesterday, which is an FAQ that they make available to help everyday Americans understand copyright. And it has a few points that I want to emphasize. And again, we've cited the actual law in our brief. But I think this demonstrative will hopefully help explain the issue. And there's a couple issues that I want to highlight. So the first is, when is my work protected? Do you see that question, Your Honor? It's the fourth question down.
Yes.
Your work is under copyright protection the moment it is created and fixed in a tangible form that is perceptible either directly or
with the aid
of a machine or a device. Your Honor, the journals, the writings of Ms. Hale were copyright protected the moment she wrote them. That's an axiomatic rule of copyright law. And that right has been transferred to us, which means it is the parents that hold that right and stand before you today asserting that right. Now, I am not a copyright lawyer. I'm lucky to have some people that have talked to me about this, Your Honor, and helped guide us in this. I did not see, essentially, any argument from anyone, except for one I'm going to address in a second, disputing the fact that we own this copyright, or that copyright begins at the moment of creation. There is a distinction between having a copyright and registering the copyright. And if Your Honor has questions, I can...
That was going to be
okay.
one of my questions,
okay.
So I'm glad that you went ahead
Yes.
and beat me
So-
to the punch.
This is partly addressed by the FAQ, so let's go ahead and address that. Why should I register my work if copyright protection is automatic? Here is what the U.S. Copyright Office tells us. Registration is recommended for a number of reasons. Many choose to register their works because they wish to have the facts of their copyright on the public record and have a certificate of registration. Registered works may be eligible for statutory damages and attorney's fees in successful litigation. If registration occurs within 5 years of publication, it is considered prima facie evidence in the court of law. The reason you would register a copyright, Your Honor, is if you want your copyrighted material to get out to the public and you want to protect your rights in it. There was a comment made yesterday that copyright is only about monetary gain. And that is not correct, Your Honor. There are numerous people that, for various reasons, choose not to publish things that they write. We can think of any number of famous authors that, wrote a great book, and we know that they wrote other things later and chose not to publish them for various reasons. Those things were still protected by copyright, despite the fact that they weren't registered. Now, Your Honor, the parents, their hope is that we will never register this copyright. Because as I understand it, registration would require that we actually take the documents and go to the Copyright Office and provide them a copy. And our entire position is that these documents should never be released.
But Mr. Osborne, you remember my earlier comment when I said, pursuant to the TPRA, the way it is written by the legislature, and I don't write the laws, but even if you are a private citizen, even if your works belong to you, if you become a victim of crime and they are collected in an investigation pursuant to the TPRA, they are subject to disclosure. So how does the court really wrestle with that? Because while the copyright may be the copyright, and registered or not registered, I don't think anyone disagrees that these are public records. I didn't see in anyone's brief that they disagreed on that point. So correct me if I'm wrong, but all parties are in agreement that the writings are public records. Is that true?
Well, Your Honor, I think that gets back to the Griffin case, and I think it would be fair to say...
And I was about to talk about
Okay.
the Griffin case.
I think it's fair to say that the parents took the position, we are the only party, I think, that perhaps did not concede that these are public records because someone has to do the Griffin analysis. But to answer your question in a more direct way, regardless of whether these are public records, the exceptions apply. And
But there's no, I know that you argue in your brief an AG opinion, but
Yes.
I don't believe, and correct me if I'm wrong, is there a Court of Appeals case or a Tennessee Supreme Court case saying that a copyright prevents disclosure?
I'll talk about that, Your Honor. So this is another one of the issues like the Victim Rights Amendment where I wouldn't say we're making new law. I think we are simply, well, okay. I would say we are simply following the path that has been laid by other cases. But the Attorney General, and the reason we gave you that is all the court has to do is agree with the Attorney General, and it can find that these documents should never be released. Because the Attorney General's official stated position to the Court of Appeals is that copyright is an exception. Now, I agree, Your Honor, that thus far, there has not been a Tennessee Court of Appeals or Tennessee Supreme Court decision that has explicitly held that copyright is an exception. And part of the reason for that is that in the case that the Tennessee Attorney General submitted its brief, which is publicresource.org, I think, versus Matthew Bender, the court didn't have to reach that question, and we can talk about the Court of Appeals' recent opinion in that case if you would like, Your Honor. But the Attorney General flat out said, copyright is an exception. So that is clearly the Attorney General's position, and it is our position.
And how is the court to construe the Attorney General's position versus the legislature versus what the courts have said?
Yeah, so I think the best way to deal with that is to talk about the case of Seaton versus Johnson, Your Honor.
And that is the railroad case.
That's
is that
correct, Your Honor, yes.
Okay.
And so in the railroad case, there was a family whose child, I mean, there is a similarity, sadly, to this. There was a family whose child was killed at a railroad crossing, and they brought a wrongful death claim. And they wanted to get records about the safety and security, ironically, since safety and security is what we're talking about here. They wanted to get records about the safety and security of railroad crossings. And what the court found, and Your Honor, I've got a marked version.
Do you want to pass that up for me? Or is that?
No, it's a mark, I didn't
For
print
you.
off 10
It's
copies,
okay.
yeah. But I can put it up on the OMO, Your Honor.
If you just want to tell me what page you're at, that would be
Yeah.
helpful.
What the court found, let me see, I think I'm looking at page 237 of the opinion, Your Honor.
Okay?
This court chooses, so dealing with a federal law that protected that information from disclosure, acknowledging all of the TPRA issues, the court still looked at this federal law that protected it from disclosure, which is what copyright does, and that's what the Attorney General says, and said, this court chooses to follow the clear weight authority cited above and to adopt the holding of Southern Pacific. This does not mean that all records of the defendant regarding railroad crossings are immune to examination by the public, but it does mean that all records used or usable in identifying or evaluating planning safety of highways or railway crossings pursuant to, cites the federal sections, are immune to examination. If the foregoing is deemed to be unjust, the remedy lies with Congress for this Constitution and the laws, I'll just put it up, Your Honor. This Constitution and the laws of the United States, which may be made in pursuance thereof, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or law of any state to the contrary notwithstanding. So the Court of Appeals explicitly adopted the Supremacy Clause and acknowledged that federal laws that are in conflict with the TPRA are supreme, and that if people don't like that result, they should take it up with Congress, Your Honor. And what I would submit is that copyright is supreme under federal law. That's the position the Attorney General has taken. That's the position we ask this court to take. It is true that that issue has not yet had to be fully resolved because the Court of Appeals didn't have to resolve it in the Matthew Bender case. And if people don't like that result, Your Honor, they can take it up with Congress. But I believe, Your Honor, that the law dictates that result.
If this court were to adopt the parents' novel argument, wouldn't that in essence gut the TPRA when it comes to any writing? You know, I'm taking notes here, I take notes on the computer, all of those are my original writings, therefore they are copywritten. So if anything that we write down is copywritten, doesn't that gut at least this portion of the go ahead?
No, I was going to say, Your Honor, you and I are definitely tracking alike, and I was ready for this question.
Okay.
Because it's also one of the, and the only issue that any of the petitioners raised in argument against this point. And so here is the thing I was looking for earlier. This is the section that we cite in our brief, section 102,
You're gonna
which
have to make
talks.
that way bigger.
I know, I will, Your Honor.
Or at least give me where it is, what page on your brief.
This is 17 U.S.C. section 102. And let me see, okay, hold on one moment.
It's all right.
I think we've got it now, right? Is that good, Your Honor?
I'm gonna pull it up, but that's fine.
Okay, so let's talk about why copyright rarely applies, even though it absolutely does in this instance, Your Honor. It rarely applies for a variety of reasons. First, most public records are actually government-created documents. And government-created documents, and this is part of what actually the public resource versus Matthew Bender case got into, government-created documents are different and are not protected by copyright. In a nutshell, we can go into further detail about what the Court of Appeals had to say in that case if Your Honor would like to. What is protected by copyright? The things that are laid out in Section A. Copyright protections subsist in accordance with this title in original works of authorship fixed in any tangible medium of expression, now known or later developed from which they can be perceived, etc. Works of authorship include the following categories. Literary works. Now, Your Honor, as Mr. King and Mr. Klett have said repeatedly, none of us have seen these writings. So I don't know exactly what these writings look like, but the way they've been described as journals and diaries fits the definition of literary works. So it seems to me that this is a literary work. That's rarely going to be the case, Your Honor. I mean, obviously any government documents are not going to be public records, And when you think about the evidence that the police collect at a scene, a statement from someone, forensic evidence they find, public video cameras that show something that happened, those things, Your Honor, are not going to be literary works, musical works, dramatic works, pantomimes, pictorial, graphic, and sculptural works, motion pictures. Now, as was mentioned yesterday, there is some reference to the notion that the shooter may have created a video, Your Honor, and that's one reason I started by saying we do assert copyright protection over her videos because of Part 6 here. But the short answer is that many, many things are not going to fall under the definition of copyright because you have Part B, and this is the part that Mr. Pierce argued. In no case does copyright protection for an original work of authorship extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described. I mean, it is limited, Your Honor. It is limited to works of creation. And everything that we've heard about the journals is that these fit. But this is a rare scenario because how often are you going to have a scenario in which a crime takes place and you have a document that is not a public document that becomes a public document because the police get it?
But I think that we're operating in this bubble because we're talking about this case. But when we think of police investigations broadly, if they go to a scene of a crime and they take what they're going to take from, let's say, your home, and you have a journal in your home that may not have anything to do with what is going on. If it comes into police custody, then it's subject to open records. And so what you're saying is if I wrote that, I have copyright on it, and it cannot come out. It's an exception to the T.
If you assert the copyright, Your Honor, I am saying that. And I want to give you an example that I've had in my head. I have young daughters, Your Honor, and like many young women right now, they are Taylor Swift fans. And so imagine a hypothetical in which, for some reason, the Nashville police had cause to search Miss Swift's residence here in Nashville. For any number of reasons, right? Not because she committed a crime or even was a target, but maybe they need some information. Imagine that they go into her apartment and they find 10 songs that she has written that she has not yet registered, Your Honor, because she has not yet put out the new album. And you had petitioners come in and ask for Miss Swift's writings. I would tell you that absolutely Miss Swift can come into this court and say copyright. They cannot force the government to release my copyright-protected material. And we are in the same position as Miss Swift. And that's a rare thing, though. So that's my position, Your Honor.
And it's your position that the supremacy clause, because it's a federal law, is going to trump.
Absolutely.
So I don't need
Yep.
to look at the exceptions. I don't need to look at anything.
That's what's so
because
beautiful about the copyright argument, Your Honor. It's incredibly simple, and it's correct, is my submission to you. And I recognize this case is going to be appealed, as Your Honor knows. I recognize that this exception, the Attorney General says it's there, so I'm just asking that the court adopt the same argument the Attorney General just made and say none of this can come out because the parents own the copyright. Why do the parents own the copyright? Because in an act of grace, Norman and Jean Hale were kind enough to give us this to try to protect our children. I mean, this is so novel, Your Honor. I don't think there's ever been a case in which the family of the assailant has tried to make amends to the families that suffered at their child's hands. It moved me to tears when it happened, Your Honor. It's a beautiful thing. And the result of that is what I'm arguing to you today.
So the Griffin case, if we go back to the Griffin case, so in the Griffin case, the wife wanted the notes back, the suicide notes. And I suppose if you were representing the wife, you would say, my husband's writings are copywritten, therefore the copy that you made for your file, you don't get. It doesn't come out.
Yeah, I would make two arguments on that. One is that the widow did not make the argument. So it's an argument that wasn't made, and had she made the argument, perhaps that case would have come out differently. The second thing is, and again, I go back to the fact that I am not a copyright lawyer, Your Honor, You know, I understand what I understand, and essentially what I understand is what I've shared with you.
Well, is
But
there a
that-
copyright lawyer in your firm?
No, Your Honor. Now, we have another firm that's been helping us, and I can,
Is there a copyright lawyer in that firm?
yes, Your Honor.
So I'm probably going to require some post.
I thought that might be a
Briefing.
result to come of this, Your Honor. And if Your Honor wants post,
This is not trial, but
yeah, we'll call it post-trial. If Your Honor wants post-trial briefing on copyright, we'd be very happy to have that, Your Honor. We've got an excellent copyright lawyer that's helping us, and so I'm happy to get into that, Your Honor. My initial reaction to your question, subject to if there's additional briefing on this, is that the suicide note probably didn't qualify for copyright protection
but why not?
because it was intentionally made public. It was a note that was left behind, I mean, it was his copyright, right? And it was intentionally left behind to be made public for people to know what had happened.
Okay, so let's take what you just said, and what you just said, and apply it to the facts of this case.
Okay? May I get some more water, by the way, Your
You
Honor?
may, please, Will. Ms. Hale left at least one of her notebooks in the car at the scene. That was most likely an intentional act by her. At the time that she did that, she owned those writings. They had not, we hadn't come and done laws of intestates, wills, whatever. We hadn't gotten there yet. So, much like the decedent in the Griffin case left his notes on the kitchen counter, she left her journal in the car. And so that was an intentional act. She wanted those to be found, I'm assuming. And they were found, because they weren't in the school, they were in the car left behind. And so if you believe that Griffin was a public record and should have come out because it was left on the kitchen counter, how is this case and those, at least the one journal left in the car, any different? You might have a salient argument on the other journals that were collected at the home, but on the journal that was in the car, that was there for consumption, assuming that she knew what was going to happen, and she left that one behind.
Well, Your Honor, I think the way you end that question sort of raises the answer. I mean, you're assuming that she knew this was going to happen
But
and left
perhaps
those.
I'm not assuming, because
Well, that's
I
true,
have
Your
a
Honor.
vantage point that
That's
you
true, Your
don't
Honor.
have.
That's true. Your Honor does have, I, having not seen those journals, not knowing what's in those journals, knowing what little I know, which is that she evidently wrote a lot, it's not shocking to me that a person who was constantly journaling would have been journaling up to the last moment. And it makes sense to me that she easily could have been journaling, but not with an intention that that's going to be found. She may very well have thought she could get away. I mean, that has happened. I think that happened with the Kansas City shooter just a few months ago initially, where they apprehended the person hours later. So it's not even an assumption necessarily that she was going to die at the scene, Your Honor. I think that just requires a lot of assumptions that makes it different from the Griffin case. Now, that too, we haven't even gotten into our victim rights argument, and we still have our school safety argument. So we have two other reasons for withholding those journals. But, if Your Honor were to find that copyright applies to everything but those two journals, then we would then say that those two journals are covered by our other two arguments, and that I'm not aware of any facts standing here today, Your Honor, that would justify finding that those are akin to the suicide note in Griffin. There may be, because as Your Honor says, you're the one who knows, not us. And I wish I could say more, but I don't know.
Okay.
But I would argue that it's different, and there's no evidence that we have available right now to say that it's like Griffin.
Okay. You can continue.
Your Honor, I think that's all I have on copyright for now, unless you have any further questions on copyright.
Should this, if we're going to go down this copyright path, should it be over in federal court? I'm a state law.
Oh, I'm glad you asked that. That's a great question. Let me address that. There was a comment made yesterday about the Matthew Bender decision, and that was an incorrect comment. I apologize, Your Honor, that I have so many papers, but as you can see, I came ready to try to address whatever questions Your Honor has, so.
I will say this copyright argument is interesting, and, you know, with this being Music City,
Exactly.
you know,
Exactly, Your Honor. That's why I think it's so important.
it's interesting.
This is going to apply to a lot of people in
Well,
this
I mean,
town, and I think the Court of Appeals would affirm Your Honor if she were to assert this exception. The Attorney General's already said that's what they think should be the law. So we're just trying to follow the Attorney General's lead here, Your Honor. But let me try to answer your question about the Bender case. Which I had printed off. Let's see. There it is. So, Your Honor, the Court of Appeals specifically said, as we read the Bender case, that Your Honor should rule on this issue and that does not belong in federal court. Federal court does need to determine certain copyright points, right? I mean, if we had to go register the copyright and seek damages because these documents that we own get released, and I hope, Your Honor, that we never go there, because that is not what we're seeking. Fundamentally, the parents are just seeking to be left alone and to let their children heal. But I agree that if there was a copyright infringement claim, we would have to bring that in federal court. But in the Public Resource versus Matthew Bender case, that case dealt with the Tennessee Code Annotated, and one of the many issues that it dealt with was whether or not copyright applied. And in that particular case, Your Honor, and we can get as into the weeds as you would like, in that particular case, the Court of Appeals was able to find and affirmed the trial court's ruling that copyright did not apply because there had been a United States Supreme Court decision related to the Georgia Code. And in that decision, Chief Justice Roberts had found that the government edicts doctrine essentially stated that government edicts and laws or government edicts are not protectable by copyright.
And your assertion would be that any writings by Ms. Hale are not government edicts?
Yeah, for sure, Your Honor, yes.
This case is distinguishable?
Absolutely. But here's the key thing. The Court of Appeals did say that it was proper to reach a decision about whether or not the exception could be applied, because in deciding whether the exception applies, you're not deciding, well, I guess I would say they were saying you weren't deciding the merits of the copyright. Now, what's interesting about this is that they had a reason to hold that copyright didn't apply in that case. And that was the reason I just gave you, which you can see up here on the next page, Chief John Roberts' decision about government edicts. But here's what the Court of Appeals had to say. While state courts may not rule definitively on copyright status, a state court does not have to utterly avoid any questions touching upon copyright. We note that the Commission intervened in this case in part to protect the state's alleged copyright interest in the TCA. It would be a curious thing if neither the trial court nor this court could address the state's purported copyright interest when that purported interest was asserted in opposition to the TPRA petition. Insofar as the trial court addressed the TCA's copyright eligibility for purposes of ruling on the TPRA, the trial court did not exceed its authority. Your Honor, that just came out, I think, in November, so you have the authority, and I would say even the guidance from the Court of Appeals that you should make a ruling on this issue. Anything further on that topic, Your Honor, that I can answer questions about?
Not on this topic. I will let you discuss the victim's right, the bill, and then I've got some questions for you guys.
Okay, thank you, Your Honor. Let me. So, Your Honor, our final argument, and again, we would submit that both of our first two arguments are reasons to not release these writings, and we would ask that Your Honor rule for us in that regard. But our final argument relates to the Constitution, as well as the statutory enactment in part. But no surprise here, because we've talked about this a lot already. Tennessee Constitution, Article 1, Section 35, to preserve and protect the victims of crime, to justice and due process, victims shall be entitled to the following basic rights. And as Your Honor well knows, we have emphasized basic right number 2, the right to be free from intimidation, harassment, and abuse throughout the criminal justice system. Note the words used, the criminal justice system, Your Honor. The criminal justice system includes the police investigations, the decision whether or not to charge a crime. You've had some arguments made that this should be restricted to only if an actual prosecution is brought.
I believe Mr. Hollow made those arguments, and he pointed to the legislative history when this bill was enacted, and particularly, I guess, the intent behind the enactment of this law was to protect, I'm looking at not Senator Burks, but maybe Representative Herron. He put the legislative history in his briefing from 1995 and basically said, you know, I don't think reporters work for the criminal justice system. They aren't a government official. They aren't employed by the government. And I would state to you, and for the record, that there is nothing in this intended in any way to limit the First Amendment rights that exist otherwise. And so Mr. Hollow, if you remember yesterday, really pointed out that he did not think that your clients had standing to argue this particular protection because there were delineated matters in the statute that the legislature has said that victims should be protected from, and we are not in those particular stages of criminal prosecution.
That's
so
correct.
I'd like to hear
Yes.
your...
So I've got several issues I want to try to address that with, Your
Sure.
Honor. The first is that, as Your Honor said, that related to First Amendment rights. This case is not about First Amendment rights. I think we all began by noting that this is about statutory rights under the TPRA. There is no constitutional right to government records. We addressed that ad nauseum in the appeal, Your Honor, about our right to be in this case, which I think also established that we have standing to at least assert this claim. Now, I, in fairness, Your Honor, did not go back and look at the procedural appellate issues that we spent time on until November because I thought those issues had been settled. So I would say, first of all, this isn't First Amendment, so that citation is inaccurate. The second thing I would say is, as Your Honor acknowledged, that came from 1995. I will not say that it does not matter at all what one senator out of many says, but a constitutional amendment by its very nature has to be passed by the legislature twice and then approved by the entire people of Tennessee. So one person's opinion is a very narrow subset of what drove the entire population of Tennessee in a statewide referendum to create this right. A third thing I would note is that the comments Mr. Hollow made related to statutes and the fact that an enabling statute does or does not go as far as the Constitution permits it does not change the language of the Constitution. Constitutional rights trump state law rights. We assert that we have a constitutional right. And the fourth thing is that I actually think that the plain language very much favors us, and we can discuss that. But this is where I get back to Mr. Gwynn's declaration, Your Honor. So I'd like to put that back up on the screen because I think it's going to be illustrative. And this, Your Honor, is the only sworn testimony in this entire case, along with that of Tory Johnson. We had two declarations, one by Mark Gwynn, the longtime head of the TBI. The other one was by Tory Johnson, who was the district attorney in Nashville for 24 years, both of whom testified under oath that they played a key role in getting the Victim Rights Amendment passed. But Mr. Gwynn has something very important to say, Your Honor. And in the same way that the court correctly acknowledged that music writers have a copyright, and so the copyright question is important. I think what Mr. Gwynn has to say shows you just how important the victim right in the Constitution is and why that matters for everyone, not just for these children. And so let me walk through his declaration, and then we'll get back to that, and then we can talk about the Vanderbilt case as well, Your Honor.
Excuse me.
Oops. Paragraph 7, former director of the TBI, 14 years under oath. I would argue the most decorated law enforcement official of the last generation, under oath. During my time at the TBI, I was an advocate for the victims of crimes. In fact, law enforcement, and this is very important, Your Honor, law enforcement depends on victims being willing to come forward to bring complaints, serve as witness, and otherwise press charges. I want to emphasize this because Mr. Gwynn goes on to say more about that. It's essential that people be able to go to the police and have the ability to file out complaints. How else can you stop people who commit rapes and who commit domestic assaults and any number of other crimes? Mr. Gwynn goes on. I remember when the Victims' Bill of Rights, which is now Article 1, Section 35 of the Tennessee Constitution, was approved and ratified. The intent of the constitutional amendment was to afford victims rights and protections through all parts of the criminal justice system, which, by the way, Your Honor, is exactly what the amendment says. The criminal justice system, which includes police investigations, post-conviction proceedings, and corrections, not just criminal law cases. I would submit to you the plain meaning is the criminal justice system. And so victims have to be protected throughout the entire system. Their right to be free from abuse, harassment, and intimidation applies to investigations, as this was. He then goes on, having just told you that he remembers when it was approved and ratified, and says, from my work with the TBI, I believe that Article 1, Section 35 of the Tennessee Constitution and the related enabling statutes are meant to apply in the context of cases such as this one, not just in criminal prosecutions. So that is the testimony you have of the director of the TBI. And then, and this I think is crucial, Your Honor, and needs to just be emphasized, from a law enforcement perspective, I think it is important that Article 1, Section 35 apply to this case. I worry that if the Tennessee Constitution does not apply to an open records request related to a criminal investigation, as is the case here, then it will have a chilling effect on future victims of crimes who may be reticent to report crimes or come forward to press charges. Your Honor, that's what's at stake here. If victims can't assert their plainly stated constitutional right, then victims are going to be afraid to come forward. And I just the repercussions of that for our society are deeply profound. And that's why Mr. Gwynn, the longtime director of the TBI, spoke under oath to this court and said, this needs to come out the way the parents articulate. And that's how I would respond to Mr. Hollow. I mean, really, his arguments, for the reasons I already stated, have essentially no bearing. And to the extent there is any testimony, anyone who actually testified, it was Mark Gwynn and Torrey Johnson. And the petitioners or Metro could have put on proof had they disagreed with that, and they didn't. Now, I can go into the Vanderbilt case in just a second, Your Honor, but that is, I want to pause and just see if I can answer any more questions about the plain language before we talk about the only case that's really addressed the issue.
Sure. So when I look at Section 135, there are certain enumerated rights wherein the legislature has said that these victims' rights apply, right? So
Yes, Your Honor.
they say the right to confer with the prosecution, the right to be free from intimidation, harassment, and abuse throughout the criminal justice system. So is your argument then that while the investigation is open, that they have this right, but once it is closed and they are no longer part of the criminal justice system, either because the assailant who has been identified is deceased. There are no other there are no other conspirators, co-conspirators, so the investigation is closed. Therefore, they're no longer part of the criminal justice system. Or are you arguing to me that this is a continuing right? And I'll let you before I...
Yeah, Your Honor, I would argue it's a continuing right. That the right attaches once you are involved in the criminal justice system, which includes investigations, and that you always have the right to be free from abuse, harassment, and intimidation. And so these records, they come in, they only exist because of the criminal justice system, and victims have this right. And those records are going to continue to be there because of the criminal justice system.
But once the investigation closes, are you arguing that victims are always a part of the criminal justice system, even when the case is closed and what is done is done?
Yeah, Your Honor, I would say that a victim always has the right to be free from abuse, harassment, and intimidation. So that someone doesn't get to come back 10 years later and say, you know, I want to dig into that case file and I want to publicize something and cause harm to these victims. That right remains, Your Honor. I don't see any reason that it would end. You always have the right to be free from abuse, harassment, and intimidation. The police keep their records, by the way, Your Honor. We understand that now that we own the documents, sometime in the next few months, Metro is probably going to return those physical copies to me and to the parents. But I understand they're going to still keep a record. They keep a record for their police files. That police file is going to exist, Your Honor. The criminal justice system continues to have that file. And we continue to remain free from abuse, harassment, and intimidation during the entire time that the criminal justice process is at work.
So if the legislature says what it means and means what it says, could they not have drafted this right, this constitutional right for victims, to say, as long as the file exists, because the way I read it, just to be completely frank, and while we focus on number 2, we also look down to 3 through 8, which really focus on the proceedings that happen once you're involved in the criminal justice system. Don't you agree with me that if well, you probably won't agree with me, but I think it is interesting that the legislature, who often, you know, can be quite explicit when they want to be, they did not say that this is a continuing right, right? They say throughout the criminal justice system, and then 3 through 8 talk about what that is. So how is this court to interpret this constitutional right that victims have in the criminal justice system to apply when a case or an investigation or proceedings are closed? Because that's in essence what you're asking me to do.
Is to interpret this constitutional right, Your Honor?
Well, you're asking me to interpret it so that this right attaches throughout the life of a file held by the police after a closed investigation.
That's right, Your Honor, we are. And I think that's what Justice Wade said in his concurring opinion, and I think that's partly what the Supreme Court also talked about in Vandy. So we can turn to that in a bit. But I don't see anything, as you've acknowledged, Your Honor, I don't see anything that limits this and says it stops. I mean, I agree. They didn't say it continues.
Sorry.
Oh, sorry. I agree. They don't say it continues in perpetuity, but if I say I've got a right to free speech, I don't need to say that I get to have that right for my whole life, or that continues until, you know, I'm not working at a newspaper or something. I still have that right.
But don't they couch that right when they say throughout the criminal justice system? Like, so you're in essence asking the court to say that once you're involved in the criminal justice system, you're always involved, and that is very expansive. Once a file is closed, when we think about open records and we think about when at least the jurisprudence that I'm going to rely on, in my opinion, when something can be released, the one thing that I can say, Atman is a little different, but I don't really think that the Atman case addressed whether or not the investigation was closed. So I'm gonna go ahead and put that out there because I know the petitioners and I would take a different view on that, but it didn't say whether the investigation is closed. Every other case, the investigation was closed. What you're asking me to do is say that that you're always involved in the criminal justice system, even after the case has come to a close, and therefore you were free, so no one can ever come and speak with you about anything.
I mean, all we're trying to say, Your Honor, is that you are protected from abuse, harassment, and intimidation throughout the criminal justice system. The system includes investigation in the police files. If the police were to give us the records back, Your Honor, and no longer have them, then we would no longer be in the criminal justice system. But since their policy is that they will always keep the records for whatever reason, then I would say those records are going to remain a part of the criminal justice system, because that is the police's, that is what they do. And I understand why they might want to keep records. And I would tell you that it's not like, otherwise you would be saying that a victim could have a constitutional right that goes away, even though those writings that could subject them to abuse, harassment, and intimidation, even though those writings remain out there and at any point could be brought back to abuse, harass, and intimidate them.
Well, I'm not saying that. That's
No,
the
I'm
way
not.
that the legislature has written the law in such a way that it has a period on it throughout the criminal justice system, period.
I agree, Your
And
Honor.
then they go through and delineate what that is. And so to say that those rights are in perpetuity after an investigation is closed, when I look at the plain language, I just don't see it there. And so you're going to have to give me a little bit more to go on. And maybe we should talk about Justice Wade and
Yeah.
the Vanderbilt case.
Let me make one last comment on this, which is just
Sure.
that I read 1 through 8 as 8 separate rights, Your Honor, each with a period. Yeah, I read 1 through 8 each as 8 separate rights. And so I don't think that 3 through 8 limit 2.
Well, if we read them as separate rights throughout the criminal justice system, that's your position.
I would say once involved in the criminal justice system, you always have the constitutional rights that the people of Tennessee decided to give to all victims. Because at that point, you've become a victim, and those rights of victims attached to you. I for one hope, Your Honor, I never have to use those rights, right? But the rights exist and they remain. That'll be my position, Your Honor.
Okay. All right, you want to talk to me about Vanderbilt?
Yes, Your Honor, thank you.
And I will tell you where I'm going on this. In your brief, you say that I have the right, basically, to make policy. And so, Mr. Hollow told me yesterday I do not have that right. And so, I would love for you to tell me where this court has the right that you assert that I have. And I love being in a court of equity. I love getting to balance and weigh, but you're gonna have to walk me through where you say that I get some of that authority that you're asserting that I have.
Yes, Your Honor. So, first of all, I would not phrase it the way that Mr. Hollow did about whether or not you have the right to, quote, make policy. I would say the court has the obligation to affirm victim rights under the Constitution. So that's how I would phrase it. You know, you obviously have heard my statutory argument that I think the plain language says that if you suffer abuse, harassment, and intimidation during the criminal justice system, you get that right. And you've heard our argument about what it means, which came from Tory Johnson and Mark Gwynn, that actually means what we say it means, and that it needs to mean that, because if it doesn't, victims will be chilled from coming forward. And that, Your Honor, is a reason, by the way, that the right should persist, because if every victim knew that whatever they come forward with will always get out eventually, again, it might have a chilling effect. So now let's talk about the Vanderbilt case. There was a comment made by Mr. Hollow at one point about Justice Kirby's concurrence that I think Mr. Hollow used the word that he, quote, excoriated Justice Wade in the dissent. It's one of the few areas that Mr. Hollow and I agree about, is that I think Kirby was a little excoriating, but not for the reason Mr. Hollow said. There's no doubt that in the Vanderbilt rape case, the court did not reach the issue that the victim argued there. I want to note, by the way, that Mr. Ed Yarbrough unfortunately could not make it here today, but he is one of our counsel, and he actually argued that case before the Supreme Court, Your Honor. So small resonance of history, if you will. But there's no doubt that the court did not reach that question. There's also no doubt that the court never said that Wade was wrong about his notion that this right exists. And I think the reason that the court, having not said Wade is wrong, but the reason they didn't agree with Wade is very illustrative of the very point that Mark Gwynne made. So the fundamental disagreement in the Vanderbilt rape case was Rule 16. And the court heard 6 hours of argument on Rule 16 yesterday, and the Vanderbilt rape case clearly established the Rule 16 exception. Justice Wade actually disagreed with his colleagues on Rule 16, which is fascinating. He would have allowed more information to come out initially because he disagreed about Rule 16. So the excoriation, as Mr. Hollow called it, was because the majority, thought that Justice Wade didn't go far enough for victims. And so I want to point out something very important, and this is found on page 876 of the Vanderbilt rape case. This is in Justice Kirby's concurrence, because Justice Wade clearly wrote about victims and their rights under the very provisions that we are articulating. And here's what she had to say. The dissent's professed concern for the rights of the victim in this case can only be described as high irony. The ruling urged by the dissent would leave witnesses and crime victims, including children, the mentally incompetent, the financially destitute, to fend for themselves in the wake of public records requests seeking their personal information, agonizing photos and videos and other sensitive information. This is what Justice Kirby was concerned about. These requests could be made by anyone, including perpetrators and their cohorts, which is, of course, exactly what Mr. Gwynne is talking about. We need to protect victims because anyone, as this court has already noted, can make a public records request. And this is presumed that the victims would even learn of a records request when they are made. And now here's what she says, which is fascinating. The integrity of our criminal justice system depends on the court setting the parameters for the flow of information in pending criminal matters. The majority in this case shoulders the court's solemn responsibility to our state. Now, that was, as you well know, a pending criminal matter. And this court, of course, has asked about that distinction. But the point here is that Justice Kirby noted that our criminal justice system depends on being able to protect victims so they come forward, which is what Mr. Gwynne said the very point of the Victim Rights Amendment is. So I would say, Your Honor, that this court has an obligation to apply the Constitution according to its plain language, and that to the extent there is any guidance, it is true that the majority did not expressly adopt Justice Wade's view. They never said it was wrong. They simply didn't get to that, Your Honor, because they didn't have to. It was not a question that they had to address on that day. But, Your Honor, we would say that that day has now come, and it is for this court to take the step that needs to be taken that Justice Wade elaborated, and that is so important for the reasons that Justice Kirby articulated.
And your position, again, is that once involved, always involved, correct? Once a victim, always a victim.
Once you are a victim, Your Honor, I would say you always have the rights of a victim. I mean, these kids aren't going to lose their rights when they're 60. And that's part of the problem, right? You know, and that'll get me to the kind of the end of my presentation in a moment, which is the facts about what the release of these documents would do. The reality is that the release of these documents could come back to haunt them at any time in their lives. And so,
What about, you know, like you all, you know, I have a vantage point that perhaps well, that you all don't have. And I understand in your copyright argument, you're basically asserting a blanket, you know, ownership right. But what about the materials that don't have anything to do with you all? Nothing. Are you asserting these same rights for those? And I get that I have information that you don't have.
yeah.
Or are we narrowing this to a particular set of documents? Because again, I guess this is the challenge of cases like this,
Right.
Where Metro and I have a vantage point that no one else has. And if there are materials that don't relate to anybody, but maybe relate to Ms. Hale and people who are not involved in this, are we going to talk about a carve out, or is it just blanket, nothing comes out?
So, Your Honor, when I get to the kind of the last point about my argument, which is sort of the facts we put on, you know, we do believe that the release of writings, period, will cause harm to the children.
Writings about whether or not I went to the store, and I'm just using that as an example.
No, I hear you, Your Honor. I think that makes sense that you asked that question, and I would say that at some level, that's what the court's going to have to decide, is if you decide that we have a right to be free from abuse, harassment, and intimidation, and you believe that there are writings that because of their, assuming you disagree with the copyright, of course, which will block all of them, and assuming you disagree with the copycat school safety argument, and also assuming, by the way, that abuse, harassment, intimidation, which could include promoting copycats, which could block all of them. But if we get past all of those issues, and Your Honor finds that we do have a constitutional right, but that there are not writings that abuse, harass, and intimidate, then I think it's possible you could find documents that could be released. It's hard for me to opine about those as you've suggested, because I've not seen them. You know, we believe, and we've put forward evidence, that the release of any writings will cause harm to the kids. Now, will the shooter writing about, I went to McDonald's today, that probably causes less harm to the children than the 3 leaked pages, which I don't think I need to talk about what was in those pages for it to be obvious
Well,
why
and
that
I
was
feel
harmful.
like Mr. Pierce honestly is going to get up here and tell me that I've been unfair to his position because I didn't let him talk about it or rely
Yeah,
on it, and then
yeah.
you'll get up here and
No,
talk
that's right,
about
Your
it.
Honor.
And so,
Yeah.
Mr. Pierce, I do. The leaked documents, again, were against the rule of law.
That's right.
And if anyone under the sound of my voice, listening or watching, intends on releasing anything else that they have, this court will not take too kindly to that, and, you know, really gets concerned about respect for the law. So anyone who's listening, you might have a plan. There that goes. So, Mr. Pierce, you know, if you want to talk to me about it, I let the other side talk. So on rebuttal, I'm ready.
But to be clear, I didn't talk about the substance of those 3 pages.
I
Your Honor.
understand.
Okay.
I understand.
And I don't want to get into that unless
Well,
you're, yeah.
But Mr. King did, allude to some of the substance, so,
Okay. Okay. You know, we said in our supplemental brief, Your Honor, that those 3 pages were awful for the families. I mean, I didn't attest to that. I have, of course, a duty of candor to the court, so I can say that now to the court, that I talked to a lot of the families that day and that week, and it was awful. And we offered, Your Honor will recall, we specifically offered to submit additional declarations about the leak and what harm it caused, if the court wanted that. You know, the court did not request that, so we didn't provide that.
No, it's
But,
fine.
so if hypothetically the shooter wrote about, I went to McDonald's today, in a vacuum, it would seem to us as adults that that might not be harmful. But anything coming out is going to be something that's out there where the person that did this to these children gets to have their voice heard, and that is there forever to haunt them. Now, I think the safest thing, the only way to make sure that you prevent abuse, harassment, and intimidation to these victims is to not release any of it. That, I think, is the prudent course. But if the court in its discretion truly believes that there are writings that are just so innocuous that they will not harm these kids, subject to, again, a copyright argument and all the other rights, then I think the court will have to make that decision, Your Honor. I guess is the best I can say on that point.
Going back to the victims' rights, and Mr. Hollow, when you have your opportunity for rebuttal, you can correct me if I was wrong, but I do recall some argument yesterday being about from the defendant, and maybe I am misremembering. In this case, when we talk about being free from all of the things that the victims' rights, the Bill of Rights gives to victims, are those couched in just the defendant, or is that to be construed broadly from anyone?
Oh, I think it's to be construed broadly, Your Honor. I mean, the prosecutor shouldn't abuse the victim either, nor should a police officer. I mean, imagine a person suffers domestic violence and comes in, and the police officer doing the intake says, "You nasty person, I'm not going to help you." I mean, I think that would be a violation of the Constitution. Now, we don't have to litigate that very often. I don't know how often that happens. Perhaps it happens a lot. We're not here on that issue, but I think victims have a right to be free from abuse, harassment, and intimidation. And oftentimes that will be, of course, at the hands of the assailant. I mean, we typically think that assailants are the ones who can intimidate and abuse victims, but an assailant's family could intimidate a victim. An assailant's friends could intimidate them. Opposing counsel could intimidate a victim. There's any number of people that could intimidate, abuse, or harass a victim, and none of them should be allowed to do that.
Okay.
Your Honor, the last thing that I want to end with is some facts, because if we are correct that this constitutional right exists, if we are correct in our plain language meaning, if we are correct in Mr. Gwynn and Mr. Johnson's testimony, if we are correct in our reading of the Vanderbilt rape case, we do still have to establish that what is at issue will actually cause abuse, harassment, and intimidation. I would tell you that it appears to me that no one has contested that the release of these writings will cause abuse, harassment, and intimidation.
Well, and that's why I asked the question that I asked, because in my purview, you know, I tried with you to a point, and then the court struggles with some of the other things that are just not related, you know, but I'll have to look into your copyright argument. Again, you all are asking me to use very, very, very broad strokes.
We are, Your Honor.
I prefer narrowly tailored.
I'm sorry?
I said I prefer narrowly tailored.
I understand that too, Your Honor. I mean, this is obviously a very unique case. And as I said, to the best of our knowledge, there's never been a case like it any time in American history. We are
Well,
trying.
not with the things that you all are arguing. I will give you that.
Yeah, because there's never been a chance to prevent a shooter's writings from coming out. And we're trying to stop this person from being glorified and aggrandized and trying to protect children. There's never been a chance to do it before, Your Honor. So I don't deny that it's a broad reading, and you know, certainly if Your Honor takes a narrow reading but still applies the constitutional right to apply redactions, we're going to be very grateful for that, Your Honor. Anything that can protect these children is something we're grateful for.
So you're saying that the parents, your position is up at you, if the court should construe this narrowly, does that eviscerate your copyright? Again,
No, they're totally separate. As I said, They're adequate and independent grounds, Your Honor. They're unrelated to each other. The copyright argument applies regardless of whether these writings abuse and harass us. These writings could all be sunny, joyful comments about how much she loves children, and we would still have the copyright. The school safety exception, if it's true that the release of these writings will inspire copycats, which again is what Mr. Gwynn and numerous other people have said, we would say that the school safety exception should be read broadly to prevent the release, irregardless of whether we meet the criteria of abuse, harassment, and intimidation. So our position is that these are three adequate and independent legal grounds. Our position is that we win under all three. Obviously, we'd be thrilled, Your Honor, to win under any of the three, because a victory under any of the three will have the result that we're seeking.
Right. Is there anything else, Mr. Osborne?
Yes, Your Honor, I wanted to finish with the abuse, harassment, and intimidation. We've put forward a lot of proof on this point. As I said, I've not seen any contrary proof. We put forward the declaration of Scott Scher. He was the doctor who treated some 80-some victims the day of the Las Vegas shooting, and who says that no one should ever have to observe an emergency room like what he observed that night. We put forward the declaration of the Alhadeffs. They are a couple whose daughter was killed at Parkland. One thing I have to say about this case, Your Honor, is that it has been I guess I'll use the word a privilege, though a heavy privilege, to have the opportunity to talk to so many victims of prior school shootings who have come out to help us. And I think they've come out to help us precisely because they know what happens to the survivors, and they're trying to make this case have a different result for the survivors here. One of the things that the Parkland shooters talk about is the fact that a student afterward committed suicide, which I understand can be pretty common, Your Honor, and it makes sense that if these writings come out, these are young, impressionable children, and they will read them, and we do not know where their minds will go. And the best way to protect them is to make sure the writings do not come out. We put forward, we also put forward, Your Honor, about 25 declarations from parents about what the children have gone through. And, I said this in our brief, to the Court of Appeals, that I cannot do justice to the words that the parents wrote. I reread all of them to prepare for this hearing. It was difficult to reread them. I wish, Your Honor, that the media would publish those 25 declarations that are all public record and not be seeking to publish the shooters' writings. I think that would be a genuine service to people if they would do that. If Your Honor would permit me, I'd like to read from two of the declarations and then submit a closing.
That's fine.
Thank you, Your Honor. I think these declarations, and again, there's so many of them, but I thought that they were excellent summations of what is at stake here. The first one, Your Honor, is the declaration of Nicholas Pilkington. Mr. Pilkington is actually in the courtroom today, Your Honor, and we're grateful for his presence. I, Nicholas Pilkington, make the following statements upon personal knowledge. I am a parent of 3 children currently attending the Covenant School. The 3 were on campus on the tragic day of March 27, 2023. As I sit to type my family's experience in life after March 27th, my hands begin to tremble. How do I put into words how that horrific day has impacted our lives? It is an experience my children will have to carry with them for the rest of their lives. All 3 of my children were at school that day, a day no one could have suspected would turn out as it did. The Covenant School is a place where our children love to go each day, where they are known, loved, celebrated, and educated. It was a place they felt safe. All of that changed in a matter of minutes that cannot be undone. While the actual manifestations of trauma have been different in each child, one thing is the same: their sense of security and safety, and their innocence has been stolen from them. Their fears may show up in different ways and places, but they all stem from the distress of that day where the assailant, the embodiment of pure evil, entered their school. As we try to take steps forward to navigate this unbearable pain, our school family is facing and heal. The threat of the release of the shooter's writings feels like we are under attack again. This person should not be given a platform to hurt our children. She stole 6 beautiful lives and traumatized so many others. We cannot give her the power to cause more harm than she already has. I can't bear the thought of giving her a voice. I can't bear the thought of knowing her thorough, premeditated plans to kill children that include my own. I can't bear the thought of my children being re-traumatized when they are old enough to search the internet and come across her evil, sickening thoughts that they and their fellow innocent classmates were the target of. With the help of counselors, we are working so hard to establish their sense of safety and security. The release of these writings to the general public would be a huge setback in their healing as well as ours as their parents. The release of the writings would also have a negative impact beyond our immediate community. And as hard as it has been for me to write this because of the feelings it has stirred up, I knew that I could not sit idly by and say nothing. I must do my part to fight to suppress her words, knowing that they would likely inspire other evil, like-minded individuals. No person, child or adult, should have to endure the pain of a senseless crime like this. I hate that our family is one of too many American families that have been victims of a school shooting. And I would not forgive myself if I didn't fight to keep those writings hidden so they do not further perpetuate violence. That's the declaration, Mr. Pilkington. And then I want to read a small selection from the Declaration of Aaron Kenney, and then I'll close, Your Honor, if I may.
I'm sorry, I didn't hear the name.
I said I would like to read a small selection from the Declaration of Aaron Kenney, Your Honor, and then I will close with a brief conclusion. Miss Kenney, of course, is the mother of William, who was killed that day. All of us representing the parents were particularly touched by her declaration. Here's what Miss Kenney has to say. It's relevant to our argument today. Paragraph 35, and then I'll read 38 through 50 and 54. We know how this cycle of violence works. I never thought for a second that my child wasn't entirely safe at this tiny school tucked away on a forested hill with locked doors, vigilant staff, and loving, courageous teachers who had undergone top-notch defensive training. Those teachers are heroes who were able to save hundreds of lives that day by flawlessly executing their lockdown protocol. But despite that, they couldn't save my child. They couldn't save the other 2 children or their 3 adult colleagues. There will always be a first few victims in these attacks. It is a statistical certainty. I never imagined the evil that would walk through the school on March 27th. I never imagined my child would not come home that day, that I would stare at an empty bed every night and every morning, reaching and longing for my child. No one imagines it can happen until it happens to you. I will not stand by and allow this shooter's writings to be published in any way and risk harm to the children, including the children of those here present today. To do so would be unconscionable. This mass murderer does not get to speak from the grave while our 3 children, along with the 3 adult victims, are silenced in this life. May this evil die with the shooter. May we deny her any victory in death. May her name, her face, and her writings be blotted from history. The pathway to obtain notoriety from murdering children must be removed, starting here with this shooter, who I will never, ever name. I find my heart heavier with grief than I could have ever imagined. Each breath, each step is an unbelievable effort. I must limp through every single hour of the remainder of my life knowing my beautiful, joyful, boisterous, talented, creative, loving, one-of-a-kind, irreplaceable child is gone from this world. My child is alive with the Lord, but separated from me. Death is the barrier I cannot yet cross. My heart's broken body now blends with the earth and returns to the dust from which we were all created and to which we all return. Despite this immense pain, I request of you, I implore you, to serve what little justice can be found for dead children and the other victims. Your Honor, I imagine you feel crushing pressure from all sides, and I know that controversy swirls around this case. But I hope and pray that you are able to drown out any external voices and soberly consider the justness and rightness of protecting hundreds of victims, mostly children, from the reviling, abusive, harassing voice of the killer who murdered their teachers and their friends. I do not envy your position, but neither would anyone envy mine. I pray as I write these words that they will not return void, and that we will soon be able to recede from the public view into our grief and what eventual healing there may be for us in this life. Now, Your Honor, I started by saying that we said at the very beginning that the parents' desire is that the word covenant will have a new meaning in American history, that it will not be like Parkland and Columbine and Uvalde. And Your Honor, we have a chance to make this case different, to be the first case where we don't celebrate a shooter and a mass murderer, but we respect and honor the victims. And that's where I get back to where I started. It's very ironic that this case is called the covenant case, Your Honor, because a covenant is a sacred agreement. In the religious context, the reason it's called Covenant Presbyterian Church is that a covenant is a sacred agreement between God and God's people. How appropriate that this case is about covenants, because what we would submit to you, Your Honor, is that there have been some sacred agreements made that need to be honored. There's the agreement the Hales made that gave us the copyright, and there's the agreement that the people of Tennessee gave to victims of crimes when in a statewide vote they passed a constitutional amendment to protect us from abuse, harassment, and intimidation. More than anything, the parents want the word covenant to mean something different than just the location of a school shooting. Let that word conjure not just tragedy, but redemption. Let the word covenant symbolize that here and now things began to change and our national obsession with violence and death came to an end. Scripture tells us that sin is passed from generation to generation, but that the Lord God's love continues forever and his righteousness from generation to generation. Your Honor, that is what the parents seek. The parents are here today because they are trying to break the cycle of violence. They are trying to protect their children and everyone's children, to stop the celebration of death, and to be able instead to rest in grace, peace, and love. Your Honor, we would submit to you that you, in your opinion, have the ability to do that and to forever change the narrative, and we respectfully request that you do. Thank you for your time.
Thank you, Mr. Osborne. I do have one question. There's
Sure.
a federal companion case going on.
Yes.
correct? So the federal courts don't have Rule 16. We are talking about Tennessee state law. And so I may hold one thing and the federal courts do something else.
Yeah, what I would say on that, Your Honor, is that while that's possible, we think it's unlikely. Our assessment of that case is that the FBI is going to win that case. FOIA actually is more limited than the TPRA. The TPRA is one of the most expansive Public Records Act. I've been told it's the most expansive in the whole country, in fact. We have not intervened in the federal records case because, as we understand FOIA law, if the federal agency will not release the documents and the FBI has refused to release them, then you do not have the right to intervene under FOIA. You only have the right to intervene once the agency decides to actually release them or is ordered to do so. So, my hope and expectation is that the federal case, which has always been on a stronger foot than this case ever, with the FBI taking a more direct and complete step than Metro has, which is they're fighting complete release. Our assessment has been that the federal case is likely to result in a victory for the FBI. To the extent that Judge Trauger, who's hearing that case, comes to a different result, if she does, then at that point, Your Honor, we would probably seek to intervene in that case. I hope we don't need to because we don't think it'll come to that. So I do believe, actually, that Your Honor's decision is highly likely to be the decision that's going to govern what happens to these writings.
Even though in past tragedies such as this, the FOIA request is usually granted. It usually comes out. So you're saying that the case that's pending in federal court, and I don't know anything about that case, you're saying that it will have a different outcome than every other tragedy and unfortunate school shooting in the United States.
If it's true that in most other FOIA cases things have been released, I'm not aware of that, Your Honor.
It is true.
Okay, then that's something I'm not aware of. What I would say is that this is not the FOIA case, therefore I did not come prepared to talk about FOIA.
Okay.
What I can tell you is that our team has looked into that, and our analysis thus far is that we feel pretty good about that case.
And
But
the covenant, in the FOIA case, in federal court?
Yes.
Okay, all right.
Now, I mean, maybe our analysis is wrong. I mean, no lawyer likes to predict how, frankly, Your Honor, I hate to be asked the question because no lawyer likes to predict how a case is going to come out, particularly a case that I'm not involved in, that we're just monitoring,
I'm
but,
not,
yeah.
I wasn't asking you, but,
Yeah.
you know, I was curious.
It would be fair to say we are monitoring it and we care about it, and it's not lost on us that this is not the only, I mean, this is an exhausting battle, Your Honor, because there's so many things going on, and we're having to constantly fight to protect these kids. And this courtroom is not the only place where we're having to do that, I'm afraid.
Okay.
Thank you.
All right, gentlemen, are you all ready for rebuttal? I'd like to keep going. If you all can keep going, you'll need a 15-minute break, and then I'll hear rebuttal. Mr. Pierce, looks like you were going to say something.
I'm ready to go. What they said a lot of things I need to respond to, but I'll get started right now.
Well, I think that maybe Mr. Berry wanted a break.